Good morning. My name is immigration attorney Pegah Rahgozar of the Rahgozar Law Firm here in Houston, Texas. We have an office here in Houston, Texas, as well as a satellite in San Antonio, Texas, and an international office in Tehran, Iran, where I'm originally from. The purpose of today's live video is to basically update you guys on the latest immigration policies that have been implemented more recently. Just to recap, as you guys are aware, once Trump came into the office, he basically began implementing a series of executive orders specifically targeting immigrants, both legal and illegal, and trying to tighten our nation's immigration policies every way he could, from the border to the internal agencies. And his goal has since been to tighten our immigration system by making it harder for immigrants both here and abroad, whether legal or illegal, from entering or staying in the U.S. and from obtaining any form of immigration benefits. And his focus, of course, has been securing the border and, of course, tightening enforcement for the sake of national security and public safety. Under his administration, there are no longer exempt classes of aliens or categories of removable aliens like there were under the Obama administration. As you guys may recall, the Obama administration had priority categories. Under Trump, there's really no exempt classes. And basically, most of his executive orders have, their policy memorandums have began defining individuals and aliens and immigrants who they're targeting. Essentially, it's everybody, but the breakdown of it are basically aliens who are found removable based on criminal or security grounds. Of course, security grounds are those suspected of being or engaging in terrorism or espionage. And anyone who has committed fraud or misrepresentation, and those subject to expedited removal. And of course, the reason for, or the basis for removal can really be any of the following: those who have been convicted of any criminal offense, those who have been charged with a criminal offense but that has not been resolved yet, those who have committed acts that constitute a chargeable criminal offense. And in certain particular serious criminal activities, ICE, USCIS actually can refer the case over to ICE, Immigration and Customs Enforcement, before making a decision on a particular application if one is pending before USCIS. As mentioned already, those who have engaged in fraud or willful misrepresentation in connection with any official matter or application before any government agency, and those who have abused any programs related to the receipt of public benefits, also those who are subject to a final order of removal and who have not departed. And of course, the immigration officer also at its discretion can also include those who pose a risk to public safety or national security. They can basically deny benefits for various reasons if they feel that it interferes or poses a risk to public safety or national security. Now, USCIS, under the immigration laws, together with the two other agencies under Homeland Security, that's Customs and Border Protection, CBP, or Immigration and Customs Enforcement, ICE, these three branches of Homeland Security basically have the power under immigration laws to issue what's called a notice to appear. And that document is a charging document notifying an individual that immigration removal proceedings or deportation proceedings are being commenced against the individual. The notice to appear basically instructs an individual that they are to appear before an immigration judge on a certain date. And now USCIS has more authority to issue notices to appear, otherwise known as an MTA, basically to issue these documents on a wider range of cases where the individual is found removable, or there's evidence of fraud, criminal activity, or if an applicant is denied an immigration benefit, so a green card, or removing conditions, or applying for citizenship, and so on and so forth, and denying that benefit. And if that individual is unlawful in the United States, those cases also get referred to the immigration court. And an example is someone who came in on a tourist visa, who overstayed that visa, happened to be married to a U.S. citizen, and therefore they applied for a green card, also known as adjustment of status here in the U.S. Their case was later denied for whatever grounds, and now that individual, because they overstayed their visa, has no lawful status, and they'll be referred to the immigration court. These guidelines, of course, are not going to cover DACA and TPS holders. There's different guidelines for those applicants or individuals. So this addresses everybody else besides those individuals who have certain policy guidelines in place. These revised policies also allow categories of cases where the individual is found removable besides the fraud and criminal activity, but cases, for example, where someone files an N-400, an application for naturalization to become a U.S. citizen, and their case is basically denied on a good moral ground basis for a criminal offense, those get issued a notice to appear. Cases where the individual has basically filed for an application such as a removal of conditions and it's denied, those get referred to immigration court as well. These new policy guidelines are effective, and so these add to the already existing policies in place regarding notices to appear, and those include categories that require issuing a notice to appear under by statute or regulation. And some of the cases that are going to be referred based on statute or regulation basically are going to be when someone files to remove the condition of their 2-year conditional resident card by filing the form I-751 to remove those conditions, and that conditional residence either has been terminated or the removal of conditions gets denied. Those cases will continue to be issued notices to appear by statute or regulation. If there is a termination of refugee status by the district director, termination of conditional permanent resident status for those who have entered the U.S. as entrepreneurs, usually through an EB-5 program. MTAs will also continue to be issued for those who get denied NACARA, which are the Nicaraguan and Central American Relief Act, and Haitian Refugee Immigration Fairness Act. Those individuals who are able to receive asylum basically from those certain countries, those categories, if their cases are denied or their adjustment of status is denied, they will also be issued notices to appear. Also, asylum applicants will get issued notices to appear if there is a denial in those cases. Now, alongside the notices to appear that we just discussed, there has been also a USCIS policy update regarding requests for evidence and notices of intent to deny. Previously, USCIS, in its discretion, would issue notices of intent to deny or request for evidence if there were evidence or certain documentation missing when an application or petition was filed. Effective September 11, 2018, as of 2 days ago, USCIS is taking a much stronger stance on adjudicating these applications and flat out denying them if they're missing documentation or evidence that goes to eligibility. If they are not initially submitted with the application, if it's required. And the reason they're doing this is basically to do away with frivolous or meritless claims that slow down the processing for everyone else. That's why we have such a backlog. Unfortunately, there are individuals who tend to file incomplete filings or ones that they're not really eligible. And it serves as kind of like a placeholder and, puts everybody else in this backlog of waiting for their cases to be adjudicated. And so basically USCIS is now taking the position that if all required initial evidence is not submitted with the benefit requested, whether that be a petition, an application, or any other request, then USCIS in its discretion can deny that benefit for failing to establish eligibility or filing a document without the required evidence. Some of these cases can include waiver applications where they've submitted maybe the initial application, but no supporting documents or evidence to establish eligibility or hardship, and so on and so forth. Cases where the regulation, the statute, or the form instructions require that a particular document be submitted with the evidence to establish eligibility, but it's not included. So for example, an affidavit of support on your family-based green card applications is required. If one is missing, USCIS now has the discretion to deny those cases without first sending a request for evidence or a notice of intent to deny. So basically, they're looking at ways to crack down on frivolous filings, meritless filings, anything that lacks the proper support that it needs at the initial outset of filing that application. They're looking to deny that, and then of course, together with the notice to appear guidelines, they can issue these cases over to immigration court. This is going to put, this is hopefully going to help the USCIS backlog, I suppose, but if everyone's getting placed into removal proceedings, we're going to see many years of backlog in terms of immigration court proceedings. But if you're looking to file an application, I highly suggest that you work with a competent immigration attorney, at least do an initial consultation, and then if necessary, I would work with an immigration attorney to file your case, because unfortunately we've seen cases where an individual really is eligible or qualified to file an application and something's gone wrong that shouldn't have, and then, but because they didn't work with an immigration attorney, unfortunately, it gets denied, and then they're referred to immigration court, and it becomes that much more of a headache. So that concludes the discussion for today. Hopefully we'll get back live soon and discuss any new updates. But as of now, those were the latest updates regarding notices to appear and USCIS's policy guidelines with regards to issuing requests for evidence or notices of intent to deny. If you guys have any questions, feel free to reach out to our office and schedule a consultation with us. We're available Monday through Friday, 9 a.m. to 5 p.m. We do both in-person consultations as well as over the phone, and also Skype consultations for our international clients. That's it for today. I hope to talk to you guys soon. Take care. Bye-bye.